So case selection is number one. That's the most important thing is case selection. And then one of the things that I tell my associates is every case is actually three cases. There's the case you sign up on day one. There's the case that you prepare for trial. And then there's the case that you actually try in the courtroom. And none of those three cases are the same. So you got to be able to look at this case and think about it in terms of where it's going to be by the time that the jury gets the case. And you got to be willing to move and adjust throughout the case. So the case selection is key. We got what's called the audit trail, which for your listeners who don't do medical negligence cases, the audit trail is an electronic document that hospitals and physicians' offices are required to maintain that tracks each and every time an individual logs into a patient's chart, and it tells you what, if any, changes, modifications, or edits are made to the patient's record. Well, in that case, we got the audit trail, and the audit trail revealed that after the patient died, several days later, the physician's assistant got into the patient's chart and modified the history and physical and the assessment.
Wow.
And he did not know, when we asked him in deposition, he didn't know that we knew and that we had the audit trail because we hadn't asked any questions about it. There was an army of defense lawyers on the other side. And one of the defense lawyers who represented the hospital, when asked what he thought about my lawsuits, was quoted in the newspaper as saying, Mr. Poppe lives in a fairy tale world if he thinks that this stuff actually happened. And one of the other lawyers told me after some depositions, he asked me, he said, Hans, how old is your daughter? And I said, she's 5. And he says, you're not going to see any money in these cases until she graduates high school. That turned out not to be the case. But that's the kind of mentality that defense lawyers have in these medical negligence cases, is that they're always going to win. And if you're not ready to go all the way as many times as it takes, you're going to have a short-lived career in this business, or you're going to have some hurt feelings, or both.
The outcome's not my job. That's their job. I'm going to trust their good people. I'm going to trust them to do their job. They're taking time out of their lives to do it. And so I'm not going to worry about the outcome. I'm going to worry about the one that's in front of me. I'm going to worry about talking to these people. Seriously, I'm going to worry about getting to know these people, talking to them, listening to them. And I'm not going to worry about whether they're good jurors or bad jurors. I got other people taking notes to worry about that. I'm not going to worry about what's going to happen in a week or two when the case is over. I'm going to worry about this right now. An opening statement. I'm going to worry about telling a story and giving these people the information they need to do their job. I'm not worried about whether I'm winning or losing. I'm not worried about what the other guy's going to say. I'm not worried about how I look. I'm just going to worry about that. And I'm not really worried. I'm just going to enjoy it. And it's made such a difference.
Lawyers who are trying to follow someone else's script or style, it's always obvious that they're not comfortable doing that. I mean, you can just tell whether that's really them or whether they're trying to sound lawyerly or sound official. And I'm like, if lawyers would just figure out who they are, which isn't always easy, figuring out who you are as a lawyer. But once you figure out who you are, having the courage to let the jury see who you really are as a lawyer, and as a person, because I think that juries are constantly trying to figure out, can I trust this man or woman? Who here can I believe? That's right. And that leads me to the third thing that I think is important about trying cases and getting verdicts. And that is, you need some help from the other side.
Yeah.
Every big verdict I've been a part of, I've gotten help from the other side. It hasn't been, I did everything right and they did everything right. It's been, I did almost everything right, and the other side gave me some opportunities that we were able to capitalize on. And that was one of them. when their main liability expert blows up on the stand and has to be admonished by the judge twice, that's the kind of thing that can alter a verdict one way or the other. The thing that I tell my associates is, like I said, there are three cases. There's the case you sign up, there's the case that you prepare to try, and there's the case that you end up trying. And the most important thing about that is getting the right case signed up. And then once you've got the case signed up, you really have to look and say, what else is there besides just medicine? Where else? Is this a business decision case? Is this a somebody made a mistake and changed the medical records case? Or is this some other kind of case? But whatever it is, you've got to look for a different angle. And as trial lawyers, that's what we got to do. We've got to be creative about looking at our cases and not saying, oh, this is just a plain vanilla case. You got to find the why. The why is the important part. It is, if this were a criminal case, it would be the motive. What's the motive here? What is the reason this bad thing happened? Because if all you're going to do is walk into court and say, oh, the doctor made a mistake, you're going to lose that case most of the time. There has to be, at least you would prefer that you find the answer to the question why, because that's what the jury wants to know. Why?